Hello, everyone. Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today, we have Mr. Shivender Kumar Sharma with us. Mr. Sharma is a seasoned lawyer based in Delhi with a legal practice spanning close to a decade, specializing in various fields like criminal law, constitutional law, anti tax evasion laws, white collar crimes. His in depth knowledge of the legal system, coupled with his extensive courtroom experience, has helped him establish a successful legal practice that caters to the clients from diverse backgrounds. So, without any ado, let me quickly introduce you all to him. Hello, Mr. Sharma. Very good morning. Welcome
Hello,
to
hello.
Lake Talk, sir. How are you?
Thank you. Thank you. I'm good. How are you doing?
Doing really good, sir. Thank you so much. Before we start, Mr. Sharma, it's an honor to take an interview for you. And thank you so much for taking out your time for this session
It's
today.
it's a pleasure. It's a pleasure.
Thank you so much. Pleasure is all ours. So, my first question to you, Mr. Sharma, is talking about your in-depth experience of criminal law. So, first question is, what motivated you to become a criminal defense lawyer, and what do you find most rewarding and challenging about this type of work?
See, as a criminal defense lawyer, my my motivation stems from a strong belief, as cliche as it sounds, but my motivation stems from a belief that principle of justice, fairness, and the right of fair trial is very important. And I'm driven by the desire to protect the rights of individual accused of crimes, and therefore to ensure that every single person in this country, in my country, get the voice, get the strong and effective defense if they are involved in a criminal case. So what I find most important being a lawyer is that it is one of the most noble professions. So giving voice to those who are not able to put their cases, it's something which motivates me. And what I find most rewarding about my work is the opportunity to make meaningful impact on people's life. Being able to advocate my clients is very important, and helping them navigate through the complexities of legal system brings this sense of fulfillment in me. Seeing the positive outcomes, of course, getting acquittals, reduced charges, or securing fair sentencing if I'm appearing from for the other side is incredibly rewarding. And yeah, this reinforces my commitment to this profession. And to see, I'll be honest, being a criminal defense lawyer presents its unique challenges. The prosecution's role is to secure convictions, and therefore the defense lawyer must navigate through the complexities, evidence, and the courtroom procedures, all these things, building strong defenses, strategies, arguments, and all these things are intellectually demanding and require continuous learning and adaptations. So, and given the fact that we have to manage with the heavy caseloads and balancing multiple cases simultaneously, so these all these things require a lot of uh, how do I put it? It's so challenging that it keeps me motivated. Coupled with the fact that I get to, on the cost of reputation, I get to provide voice to those accused of crimes, is uh, is what I believe drives me as a criminal defense lawyer.
That's amazing. That's amazing. Really nice to hear that how motivated you are in terms of helping out your clients, and this really means a lot for us.
Hmm.
Coming down to specific one part where you mentioned about your skills. So, what do you see as the most critical skills for a criminal defense lawyer, and how have you developed these skills in your practice?
See, there are several critical skills that those are essential for the effective representation of clients. See, as I told you earlier, navigating through the complexities of legal system. Some of the skills which I have developed during the course of my practice is um, legal knowledge and analytical skills, having a deep understanding of criminal law, legal procedures, and relevant case precedents. These are crucial. These are very crucial. So I try to continually engage in legal research, attend seminars, and I try to join as many workshops as I can, stay updated. with the changes in the legislation to enhance my legal knowledge. And the other thing is, other skill is strong advocacy and communication skills, which we are lacking in today's era. The young lawyers, I don't find many of the young lawyers having these skills. Effective oral and written communication skills are vital for any criminal defense lawyer. For me, I would say I've honed my advocacy skills by regularly appearing in the courts, presenting persuasive arguments, cross-examining witnesses, and I focus on clear and concise written submissions. I've seen young lawyers filing these bunch of papers in the court, but they don't know what to say, what they want to address, what legal issue or what legal precedent they are or legal proposition they are invoking before the court. So that is very important. And the most important of all, cross-examination. Cross-examination, this skill of cross-examination is of paramount importance for a criminal defense lawyer, I would say. It is not only a skill, it is a tool that is used to challenge the credibility, reliability, accuracy of a witness, which is testifying against your client. Some of the important questions and strategies of cross examinations are to uncover contradictions, and we have introduced witnesses, entrusted witnesses, so therefore to impeach the credibility of a witness, create reasonable doubt, most importantly shape the narrative in a case, in a criminal case. Yeah, to strengthen the defense case. So I would say above all, cross-examination is the skill which is the most important skill, and it cannot be owned in a day or two or in a couple of years. You need practice. You need to appear before courtrooms. I tell these things to all of my interns, my juniors, everyone who speaks to me. If you want to cross-examine, don't shy away from the cross-examination. If you want to be a good criminal defense lawyer, appear before court, cross-examine. Cross-examination is the tool which will make you from a lawyer and to a good criminal lawyer. It will make you stand out. Other skill, I would say, when it comes to criminal litigation, lawyers tends to get involved personally. That is one thing which one should keep in mind, that keep yourself as professional as you can. You are handling a case, don't get yourself personally involved in a case. So yeah, these are some skills which professionalism is not a skill, but I would say this is something which one should learn and one should incorporate in the practice. Don't get personally involved in the cases. It will harm you in the long run. So yeah.
Thank you so much, Mr. Sharma. Thank you so much. This really seems like an inspiring speech for all of us, that how exactly we or the one should be a perfect lawyer when we specifically talking about white collar crimes or criminal laws. But since we are majorly talking about cross-examining, one thing that I would like to know is, what strategies do you typically use in cross-examining? Because I hear you mentioned that there are multiple strategies that can be used when it comes to the cross-examination. And how that, or I would say, how do you decide that which strategy to be used in the particular case?
See, in cross-examining witnesses and challenging evidences in criminal trial, there are various strategies, and I try to employ strategy tailored to the specific circumstance of a case. So that is very important, that which strategy to employ in your case. Selection of strategy depends on factors such as witnesses' credibility, strength of the prosecution's evidence, what is your defense, what is the defense story that you have put to the other witnesses, and overall the trial strategy is very important to take into the consideration. See, some of the common strategies is impeaching the credibility. Now, in this strategy, one tries to challenge the witnesses' credibility by exposing biases, inconsistencies, prior inconsistent statements. And this may involve pointing out the discrepancies between their testimonies and earlier statements, highlighting any personal interest or motives that may affect their testimony, or or revealing any criminal record or dishonest behavior. See, criminal record in our criminal jurisprudence does not matter that much, but we try to do that. We try to implement to shake their mind. All right, challenging the perception and memory, that is the other strategy. A witness may have a limited, see, human, there is a limit to human mind, human tendencies. There is a limit to that. One can remember, one can recollect a small batch of things, right? So witnesses also may have limited memory or inaccurate perception or memories of a particular event. See, in such cases, I employ questioning techniques to expose limitations, inconsistencies, or biases, potential biases in their observations about the facts they are testifying. Say this involves a set of questions which impeach their ability to accurately recall details, their line of sight, or the level of attention during the particular incident which they are deposing about. Establishing alternative interpretations. This is also very important thing while cross-examination, to present alternative interpretations to the evidence, and I would say to challenge the prosecution's narrative. One has to, in a criminal defense, in a criminal trial, one has to set the narrative. The side setting the narrative will take away the case, I would say. So it is very important to set the narrative. So for that, establishing alternative interpretations is very essential. All right. So by highlighting the gaps in the witness's knowledge, suggesting alternative explanations to the fact they are deposing to. See, you are deposing a particular fact. Let's say, for example, a witness is deposing a particular fact, particular line. That statement could have alternate interpretations, alternate explanations. So by establishing that alternate interpretations, which goes in favor of your defense strategy, is very important. Thereafter, highlighting inconsistencies in the prosecution's case, that is very important. In the contradictions in the witnesses' testimonies. Let's say prosecution has cited 10 witnesses, and they have cited 2 or 3 witnesses for a particular fact. One witness is coming to the court and deposing A thing about the particular fact. Second witness to the same fact is coming and deposing B, and third witness is coming, is deposing Z. So the contradictions in the testimonies of the witness and how to put what contradiction is coming to the next witness, that is also very important. Eliciting admissions through skillful questioning, one can seek to elicit admissions or favorable information from the witnesses that supports the defense theory. This may involve asking leading questions also, hypothetical scenarios, and one thing which, because I have you asked this question and I have seen this in my practice, and it's very common these days. What happens is, in a criminal case, when there are expert witnesses, let's say there are doctors, or let's say in a murder trial there is a post-mortem doctor. Most of the lawyers don't cross-examine these witnesses, believing that these are just formal witnesses. It's no need to cross-examine them. Whereas the matter of the fact is, it is very crucial to examine expert witnesses. Go study medical jurisprudence. Question them on that. See, while you cross-examine expert witnesses, you have the opportunity to focus on their qualification, methodology, potential biases, and by questioning their expertise, credibility, or potential conflicts of the interest, you can strike for. So, in all, one has to shake the confidence of the judiciary in the witness. You have to challenge the very case of the prosecution to the core. So you have to cross-examine every witness. And coming back to what you were suggesting, because this question, one can write a book about it, how to cross-examine. So I'll sum up in this way: the decision on which strategy to employ in a particular case is based on thorough analysis of the facts, evidence, witness profiles, and it requires careful consideration of the defense theory, right? So the goal is to challenge the prosecution's evidence, undermine the witnesses' credibility, and present a compelling defense that raises a reasonable doubt in the minds of the judge. The specific strategy that has to be employed in a cross-examination should be tailored to achieve this sole objective, that you have to impeach the credibility of the witness, elicit your favorable answers, and shake the witness. It is very important in cross-examination to what not to ask rather than knowing what to ask. That can only be achieved when you practice. It cannot be learned in a day or two. You cannot learn it while going through a cross-examination which some other lawyer has conducted. You'll have to practice that. You have to build strategies for that. When you'll build the strategies, you'll be knowing, oh, this is the question, very important question I should be asking from this particular witness. Oh, I should not ask this particular question because this will go in the favor of the prosecution and it'll bite me. So that is very important. So practice. Whenever you get the opportunity to cross-examine, go through your file, make a solid defense, discuss it with your seniors, go for the cross-examination. Don't miss out on any opportunity you get to cross-examine a witness.
Thank you so much, Mr. Sharma, for such a great insight and letting us know that what exactly the strategies and how everything of the one should do to be a perfect criminal law. So thank you so much for that.
Mm.
To move ahead, one thing that I would really like to know from you is, since there are multiple changes that have been happened, so have been incurred. So how do you keep up with the changes of criminal law and legal precedents that could affect your client cases? What resources you rely on for the research and analysis? If you can share some lights on this.
See, there are two things. One, you can go old school, and you can adjust with technology. So I try to balance the both of them. I am a bit old school, and because the technologies we are taking over the most of the publications, so I try to implement that also in my practice. See, going through the legal publications and journals, it is very important to keep yourself updated. Read, there is no shortcut. You have to read. You have to go through the precedents. You have to go through the judgments of the Honorable Supreme Court of India. You have to go through if you get time, of course, other high courts, and you have to, like I mostly practice in Delhi, I don't miss out on any judgment. I try not to miss out on any judgment, I would rather say, which has been passed by the Honorable High Court of Delhi. So read legal publications, journals, case law research for if we are researching for a case, my team is researching for a case. So that is very important to and nowadays we have tools for that. There is SCC online and the bar and bench, live law, these type of tools. One of the platforms that I personally like is LegitQuest. It's a very good platform, and see, then I try to attend workshops. I try to attend seminars that are organized by the bar associations or professional organizations, because the knowledge comes from discussion also. No? You have, see, if there is some development in civil side of the practice, I might not come across that because I'm majorly practicing on criminal and constitutional side. So discussing with other lawyers, I love spending time with my peers and the seniors at the bar. Whenever I get time, I try to have a coffee with them in the bar room and discuss what's going on, what's the legal issue which the Honorable Supreme Court is dealing with these days, and what's their take on that, what's my take on that. So discussion is other important factor, and I would say this is the branch of the continuing legal education. Whenever one pass outs from the law school, see, education doesn't end. This is the profession where you will have to be educated till the very last day you practice. So learning process never ends. So therefore, I like to term it as continuing legal education. So try to get involved in discussions and debates, and I try whenever I see I have a touch wood, I have a good practice. I don't get the time that often, but whenever I see legends from my bar arguing a matter, I try to make time and listen to the argument. I try to monitor court proceedings which they are conducting. So that these things are very important. You once the day you stop learning, the day you should stop practicing, I would say.
Yeah, that's so true, Mr. Sharma. That's so true that there is no age to learn. If someone wants to grow, then
Mm.
learning is one of the most
Mm.
essential part that the one should know.
See, what happens is by leveraging these resources and adopting a proactive approach to staying informed, one has to ensure that they are up to date with the changes in the not only in criminal law but in their practice, I would say. So this allows them to provide the most effective representations for their clients and navigate through the legal complexities as well. So that is very important.
Exactly, exactly. Thank you so much again, Mr. Sharma, for sharing your insights on such a brilliant topic that how the one can be a right fit in terms of learning and for majorly for the legal. So thank you so much again. This one thing that I would really like to understand about the current system legal is that how would you rate the current legal system drives towards encouraging access to justice? Do you think that is there a tangible movement in closing the justice gap?
See, I'll be very honest with you, and I would assess the current legal system's drive towards encouraging access to justice as a work in progress. See, while efforts have been made to improve access to the justice, there is still a significant justice gap that needs to be addressed. India has implemented various measures, I would say, various measures to enhance access to justice. For example, now legal aid clinics are there, lok adalats are there, and provision is there for the legal aid to the marginalized section of the society. And additionally, the introduction of online case filing systems these days and virtual court proceedings, all these efforts are being done aiming only to make the justice system more accessible and efficient. But however, despite these initiatives, several challenges persist. The justice system continues to face issues such as backlog of cases, lengthy delays, right? Inadequate infrastructure, limited resources of judges, all right, and there is shortage of judges also, all right. Complex legal procedures are there. All these factors hinder timely resolution of cases, and furthermore, there remains a significant access to justice gap, particularly for the marginalized communities, economically disadvantaged individuals also, and those I recently I did a case where I got to know that those residing in remote areas, they don't have that much access to the judicial system. So there are socio-economic barriers also, lack of awareness also about their legal rights, and I don't know why I should be saying this or not, but I've seen this. The high cost of legal representation also at times often prevent many people from effectively accessing the justice system. Having said that, I would say while some progress has been made, there's still a need for continued effort to close the justice gap in India, and this requires multifaceted approach, which includes increasing legal aid availability, addressing the backlog of cases, enhancing legal infrastructure, promoting legal literacy. That is of utmost importance. Legal literacy, we have to work in that direction. Then exploring alternative dispute resolution mechanism, which is very effective these days. So ultimately, tangible movement in closing the justice gap will depend on sustained commitment from all the stakeholders. It cannot be you and me solely, or the government solely, all the judiciary solely. We all has to put in, all the holders have to commit to that, including government, legal professionals, civil society organizations, and the judiciary. I'm so sorry. And by collectively working towards improving access to justice, I think we can strive for a more inclusive and equitable legal system in India, I believe. So yeah, I think it's a work in progress.
Thank you so much, Mr. Sharma, for sharing such great insights with us and making us aware that how the one should always be when it comes to the legal industry. So it was a real honor to have this chat today. So it was really a real honor to have a conversation with you. We
Thank you.
look forward to have a chat with you again in future on some really trending topics that we have across in the international legal fraternity. So, Mr.
Even I
Sharma,
would love to have that conversation.
Mr. Sharma, once again, thank you so much for taking out your valuable time and joining early in the morning today and having a beautiful conversation and letting us know and inspiring lots of individuals as to how the one should always grow in terms of, or specifically in legal. So, thank you so much again for your time.
Thank you so much. Thank you. It was lovely talking to you.
Thank you so much again. So before we conclude, for our viewers, if you like this chat, I would request you all to please like, share, and subscribe to ClickAway Creators YouTube channel to appreciate what we do. And as I said earlier, you have more coming us from the great industry leaders. This is Krish from LexTalk World with Mr. Shivender Kumar Sharma signing off. Thank you.